10 years ago, if you had mentioned wrongful convictions, people might have responded that while they are terrible, they're rare. Today, though, most people realize that they are not. In this presentation, we will once again look at the role of prosecutorial misconduct, this time from a regulatory perspective. Hi, I'm Connie Marsh, founder of the Innocence Foundation, and today we will review prosecutorial misconduct, its history, scope, resultant harms, and especially the role played by unqualified immunity. Next, we'll go over how the courts and legislatures have weighed in, as well as how the executive branch might be the best venue for finding a solution, at least in the short run. And last, we'll go over longer-term solutions. In America, prosecutors began as appointed officials. Today, however, they're usually elected at a county level. They've been called the most powerful people in America, and yet many believe that they abuse their power when they use it to convict the innocent. As we'll see, prosecutors are exempt from all civil liability, even when they knowingly present false evidence in court. No one truly knows how many innocent people are in prison because the federal government does not track this phenomena. However, according to the National Registry of Exonerations published by Michigan State University, there were 233 exonerations nationwide last year, 2022. And official misconduct, whether by police or by prosecutors, was a known factor in at least 84% of those. As for prosecutors specifically, they committed misconduct in 30% of the cases, and you might be surprised to note that it is they and not police who are responsible for most of the hiding of exculpatory evidence. Likewise, prosecutors committed a substantial amount of witness tampering and misbehaved at trial in known exonerations. An interesting side note, in federal white-collar cases, prosecutors committed misconduct 7 times as often as police. You may be asking, why would a prosecutor do such a thing? Well, the number one reason is because they can. Disciplinary actions against officials who committed misconduct are uncommon for all types of officials, but especially so for prosecutors. Wrongful convictions cause harm to crime victims who, in a rush to gain closure, are too easily sold a false sense of security, and secondly, to the innocent person whose life is stolen. Third, to all of us, remember, for every person wrongfully convicted, another is wrongfully freed, and this makes none of our communities safer. So let's start dissecting how each of the 3 branches of the American government might contribute to a solution. First, the judicial branch. Unfortunately, history has not shown courts to be willing to rein in prosecutorial power. Instead, the Supreme Court in Embler versus Prachtman entrenched doctrines of absolute immunity for prosecutors, even when they hide exculpatory evidence, which is otherwise known as a Brady violation. You heard that right. While the immunity enjoyed by police is qualified, in other words, it has certain limitations, the immunity that prosecutors enjoy is unqualified or absolute in a civil sense. Some might go so far as to call it total impunity. Now, you might ask, well, what about in cases where there's a deliberate attempt by a prosecutor to conceal evidence that might otherwise free an individual? Sorry, still exempt, according to an affirmation expressed in 2009 in Van de Kamp versus Goldstein. Another principle at play here is that of stare decisis, which means that once a court decides or establishes a pattern one direction, it's going to be unlikely to change course. When you add stare decisis to the fact that courts defer to executive agencies nearly 3/4 of the time, you will see why the judiciary is an unlikely source for change anytime soon. And even when there are cases like Skidmore or Kaiser that claim to impose controls on agency decisions, in reality, their common law has only paper teeth. The legislative branch. Many times we approach a legal matter from the top down. For instance, what's the federal position? How well do states align with that? And are there any matters of conflict significant enough to warrant preemption consideration? But not here. Simply put, because Congress is surprisingly quiet on requirements for those practicing law, so far courts have little to nothing to review. And even when good legislation, such as the Fairness and Disclosure of Evidence Act would foster case integrity and align with existing common law, it gets significant resistance from organizations such as the Department of Justice. Interestingly, in 2020, for example, a New York judge struck down as unconstitutional a commission that the state legislature had approved to investigate prosecutorial misconduct specifically. So that ruling will have a chilling effect to any legislatures seeking to implement controls on run-amok DAs. So how can we hold prosecutors accountable? Actually, the executive branch can weigh in. By decrees known as executive orders, presidential administrations seek to influence the policies of local prosecutors around the country. Well, at least that's the idea. Some might argue that these local officials are going to wield their discretion at whim, regardless of what is happening at a national level. But surely at least some of them will feel a little freer to act when their position has the declared approval of a sitting president. One objection to relying on the executive branch as a catalyst for change is that administrations tend to change out every 4 to 8 years, so gains will be short-lived. And even when a candidate gives every indication that he intends to be smart on crime as opposed to tough on it, they may or may not follow through. So we've just looked at all three branches of government for regulatory assistance and reform. So what's next? Since states are the ones who admit lawyers to practice, it's primarily they who govern industry responsibilities. But from where do they draw their rules? Well, they tend to defer to the model rules of professional conduct that were established in 1983 by the American Bar Association, now headquartered in Chicago. Some may criticize that these codes focus on legalities to the detriment of moralities. In other words, what attorneys can or must technically do, in contrast to what they ethically ought to do. At any rate, the takeaway here should be that the organization that is most looked to for guidance on how attorneys should practice law is a private one with no official status or home among America's three branches of government. Here in my gorgeous home state of Oregon, despite existing codes, I can tell you that a prosecutor can seemingly do almost anything and get away with it, at least in Clackamas County. In 2020, Oregon Supreme Court mentioned my husband's prosecutor, Russell Amos, in conjunction with tampering with a witness in yet another 2014 case, the Weaver one. The common denominator with ours is that the focus of Amos's prosecution always seems to fall on someone whose conviction will gain him the better publicity. So far, our complaints have fallen on deaf ears, but Oregon State Bar did invite us to try back after we win exoneration at Floyd's trial in a few days. But at that point, I kind of expect him to say, well, you won, so why are you complaining? So I propose 4 solutions that will hold prosecutors accountable. First, through a series of rewards and sanctions, we must encourage DAs to adopt cultures that hold respect for life and justice. Second, we need bar associations who are willing to brandish the power they have. Third, prosecutors need federal oversight. And finally, we need a strong, well-funded innocence organizations to drive exonerations. So let's break that down to see how each leg of our solution relies on the other. First, the DA. Conviction Integrity Units, or CIUs, are internal divisions of prosecutors' offices that work to prevent, identify, and correct false convictions. Let's be honest, it's very difficult to legislate moral fortitude, or to obtain it simply by adding another bureaucratic layer. Just look at internal affairs found in any police department. Public entities of all sorts tend to entrench when they're faced with embarrassment, liability, or other political fallout. Even so, while prosecutors certainly should not be allowed to be a law unto themselves, they should be welcomed at our table of reform. Once again, the ABA's model rules direct, and I quote, "The duty of the prosecutor is to seek justice, not merely convict." Unfortunately, many prosecutors cherish their win ratios above all, which means that many of them convict whom they can, and not always whom they should. If the ABA really means what it publishes, it will recommend incremental sanctions against DAs who violate its stated principles. Just think what would happen if the same people who issue licenses to practice law were willing to suspend or revoke them in the case of abuses, just like DMV or a liquor license. What a concept. Instead, prosecutors are rarely punished even for intentional serial violations of justice. Only 2 prosecutors, yes, ever, as of 2022, have been convicted for crimes related to the imprisonment of the innocent, but it was labeled contempt of court. And while both of these gentlemen did lose their jobs and their law licenses, one of them spent just 1 day in jail, and the other 4 days in jail in exchange for the 24 years that he stole from Michael Norton in Texas. Judge Kaczynski's article, as summarized in the Washington Post, calls for several specific, well-studied reforms to ensure that only the guilty are punished. And one of my favorites is the suggestion of a federal oversight agency that will, quote, investigate the problem of questionable state convictions. He goes on to say, this will reduce the bias that one state agency might have in favor of another, end of quote. I additionally propose that this should incorporate routine audits and investigations with published rankings of counties by state for constituents to access. Further, a couple slides ago, we talked about the conviction integrity units being internal divisions. So in contrast, here we have innocence organizations who are independent, objective, and almost always nonprofit. Yet each year, even underfunded, these IOs attain noticeably better numbers in freeing the innocent. It should be noted that DA offices do collaborate with innocence organizations about half the time, but doesn't the track record shown on this chart make a great argument for diverting some public funding to effective IOs? Forgive me, I cannot close without a word about restorative justice. Much of the reason prosecutors get by with what they do is because of the secretive and adversarial structure of our legal system. Traditionally, we are all accustomed to the idea that guilty people either won't or shouldn't come clean about their actions, so prosecutors must trick, coerce, or otherwise seek justice within this arrangement. Typically, prosecutors ask, what's the law, who broke it, and what's the rightful punishment? This is punitive and offender-focused. Restorative justice, on the other hand, depends upon honesty, transparency, redemption, and sometimes even forgiveness. It's where we ask who was harmed, what are their needs, and whose obligations are these. This is an authentic, survivor-centered process, and it's the only method of dealing harm that promotes healing, safety, and forgiveness to the degree possible. I don't have all the answers, but somehow we must find room for it. I cannot help but speculate that adding this one component to investigations could possibly reduce wrongful convictions by 99%. To wrap this up, wrongful convictions steal thousands of years of life. Removing prosecutorial immunity will reduce these. Ideally, this will take the eventual coordination of the judicial, legislative, and executive branches of government. Meanwhile, bar associations can exercise the power that they already possess to enforce codes of conduct they've already written, and exonerators of all sorts can continue to work together and reunite families of those who are wrongfully incarcerated. The cemetery photo on this slide and the headstone on the photo in the prior one were taken at a historic cemetery about 2 miles from my front door. So how far have we come? Not enough. Here's what you can do. First, support your local nonprofits that help free the innocent. Second, urge the ABA to promote strict sanctions for prosecutors who knowingly miscarry justice for their own personal gain. And finally, join me in a public education campaign. Please let your friends and family know that you care about this issue. The word is getting out, and it must continue. If we do these things, perhaps court and Congress will find the courage to address the unmitigated immunity that has led to an unprecedented imbalance of prosecutorial power. Wrongful conviction can happen to anyone, and no one deserves to serve time for the crimes of another. Thank you.